because that's how the law works. Is if I have no way of knowing, or you're actively concealing it, which we see all the times with the processor. I mean, the whole system is made to actively conceal.
Well, the funny part was the response that he got back. It was like $1 million issue to him. The response that he got back was, well, we haven't been passing through all these interchange fees, so you owe us $2 million.
Yeah,
it's
so
like,
just be quiet.
Yeah, basically,
and go away.
Basically,
and they're going, but we won't collect that from you if you shut up and go back to bed.
That's right. Oh yeah, let's memorialize that we don't owe you anything and you don't owe us anything.
Yeah,
right?
exactly.
Yeah. Welcome to the Payments Experts Podcast, a podcast of Global Legal Law Firm. We hope you enjoy this episode. Got a very exciting podcast today. Joining us in studio, our founding and managing partner, Christopher Dryden, as well as James Huber, managing partner of Global Legal Law Firm. Gentlemen, this is our 100th episode. It's been over 3 years now. Congratulations.
Yeah, so I've been celebrating all morning.
All morning.
In between doing work.
In between doing work. So we wanted to start off the episode talking about the Illinois brick interchange ruling. What happened in that case is everyone goes, this is ridiculous, because they made a rule saying you can't charge interchange on sales tax. So the interchange is typically charged to the transaction as a whole. And a lower court said, no, that's not going to work. And the ETA and the processors and everything go, no, this really isn't going to work because we don't even know how we're going to do this.
Yeah, I mean, it's impossible to figure out.
Well, I thought I figured it out. And I can't remember what I said. I was like, it's not that hard. I mean, obviously someone just has to write some software, but I was just, basically you charge the interchange here, and then this thing just rides the rails for free.
Well, I listened to you yesterday and a lot of it made sense, but here's something that, maybe it's ride the rails for free, but like for geolocation this is related to Illinois merchants.
Right.
What happens when you have a website and the website registrant is in a state other than where the merchant is? Where is the sale actually taking place? I mean, there's case law that talks about taxation and whether or not a certain jurisdiction's tax laws apply to, like if I'm in South Dakota and I buy something from a New York company, that New York company is still subject to South Dakota's sales tax laws because they're entering into South Dakota to do the transaction. So it'll be interesting to see if there's like carve outs for different ways that the transaction's occurring. Like, does the location of the website registrant, or where is the actually being processed and settled? Will they try to dissect it out to show that it's not really touching Illinois? Like, is that the next, kind of the next analysis that happens? I don't know.
It's a nightmare. And when it came out, the underdog in me is like, yeah, stick it to the processors. And we all rely on the processors, and but one of our big things is we're always fighting with the processors. And I remember it was probably like 15 years ago, we were getting vetted to work for one of the processors to do lease collections, and we were going through the process and it was really long, and then all of a sudden a light bulb I think went off with both of us of, we don't want to work for the processor.
Yeah.
Because all of our clients are always fighting with them. We're going to be conflicted out. It ended up being a good business solution, but part of us is, the maverick. I'm going, yes, stick it to them. But then I go, well, wait, they're not going to be stuck with this. Guess who's going to pay for this technology, everything? Because Visa and MasterCard, they might say, you're not riding the rails for free. We're going to charge. You're getting charged the interchange. Fiserv, fine. The card holder's not. You're going to get it.
Yeah, like what happens to interchange? I mean, because now you've got institutional construction changes that are going to have to take place, and it's not a simple fix. And the real problem is that if it's okay in Illinois, now the Colorado bill that's out, it's okay in Colorado. And so for every single state, are they going to have to redesign how interchange operates?
With different rules.
Yeah, like there won't be any standardization. It'll make it more expensive. It's actually more that the card networks can hide behind to pass along costs and profit with it, in my opinion.
Right. Yeah, but then it all goes, we're going, oh, well, we're protecting the consumer, but we know that the issuing bank, the bank that gives you your card, they're pocketing most of interchange, right? They get 3/4 of it or a little more.
No, about 3/4.
About 3/4 of the interchange goes to the issuing bank, and we're going, oh, we're protecting them. If these guys are getting less or having to pay for it, it ends up hurting the consumer. So,
well, I think the rising prices, like, look, you add costs onto the. This is a constant. Like when we were talking about, hey, what do you want to talk about for the show? It's this constant push pull, because oh well, we give you the surcharging ability, but do you really? I mean, we just did a CRM migration to a new CRM system for our operations, and I've been fighting with the guy that is our representative when he told me it was against the law to charge more than 3% in a surcharge, and I went, whoa. I said, first off, like,
do you know who you're talking to?
Like this. That's not. You just said that's a law. Please tell me the law. And it's not. It's a card network rule for Visa. MasterCard's still 4%, even though they may come down to the same point. But everybody's kind of like towing this line. And the ISV that we're with, they force us into the payment processing relationship. They wouldn't even let us give our own statement
disclaimer
about it. Yeah,
right. We're going,
about it. Like, this doesn't work. And we're trying to tell them, you guys should probably hire us about this stuff. But they wouldn't. They limited our ability to actually, in their system, do surcharging. Like, we still have to eat a significant portion of the Amex charge, because it's the cost of acceptance versus what they cap. And they don't even understand what's going on. And the reason I bring it up is because what's going to end up happening is now we have these dueling and competing forces of surcharge limitations, a lack of transparency in how you can do cash discount legitimately without getting fined by the card networks, and then potentially increasing interchange costs around the Illinois case, and in the middle is the merchant. And dude, when you're mom and pop, you don't know any of this stuff. I mean, it's kind of ridiculous.
Right. Or when you're, a judge or in the legislature, they can't figure it out. I just thought of another potential problem. What do you do with dual pricing in Illinois? You're going to have 3 prices now.
Maybe.
Wouldn't you? Because you have your cash price is just what it is. And then you have your card price with this on the side. That's a nightmare.
Yeah, well, it's interesting that this came out. I had another client come to us related to a particular business segment where they're doing surcharging, and their whole pitch is, let's do compliant surcharging. Nobody's really doing it right. And they sent me a Wisconsin law, and the Wisconsin law calls the surcharge a swipe fee. But they're having to do some reprogramming in their software, because for Wisconsin merchants, you can't surcharge sales tax. So what ends up happening is the list price, you add your surcharge to that, and then you apply the sales tax. So ultimately, you're only getting 90% of the surcharge amount,
right? Because
the sales tax then can't be included. So then you have to pay the sales tax back. And so rather than just attributing it all to the list price plus the surcharge, now there's a rebate back to the states because they're trying to take it off of sales tax. Similarly to Illinois, where you can't charge interchange, now they're saying that a surcharge, they're treating it the same way and really kind of exempting sales tax from its application.
Right.
I thought that was super interesting too.
Well, who does it apply to? Does it apply to Visa, MasterCard, the merchant? Who's going to be called in violation if your machine's malfunctioning? Or it's just operating as it do now.
The ISO, because that's who programs the machine a lot of times.
And so, yeah, but I
actually saw language in an agreement. I don't know if I want to say the company, so I'll leave it alone. But it was one of the first times I've ever seen it from a upstream vendor, from a agent ISO perspective, where it had a whole clause about programming the equipment and any errors in programming. Now, I think the clause was more geared to if you program the wrong DDA in and the money gets misdirected. Right. But I could see what you just said, this being a clause coming in every contract, that if you're taking the compliance of whatever equipment's being used and you're programming it or you're connecting it to a software system like the physical device, whatever you're doing.
Right.
If for whatever reason there is a miscalculation of whatever rate or fee or whatever's being regulated, yeah, I think then it gets pushed down.
It gets pushed down,
Yeah.
all the liability, because that's how it always happens.
That's how it always happens.
So
it's either the merchant or the ISO that's going to eat it. And I hesitate to say agent, because the agents are people that they're not going to be able to satisfy some of these hefty fines that go along with this. I mean, they don't think about when they're doing the regulatory fine framework. They're not thinking about the fact that there's all these levels, like you said, a judge, somebody in the legislature, they don't understand
Right.
necessarily like who this is going to impact and how and
who enforces it? I mean, I'm guessing it's going to be
the Illinois state. The
Illinois
state of
State, or it's going to be plaintiffs' attorneys. The ambulance chasing.
Yeah, but was
scourge
there
of
a
the
private
earth.
right of action?
I don't know. I haven't
didn't
looked
see
at it.
Yeah.
But so, how do you enforce that, and who do you enforce it against? And I think you're right. It's going to fall on the ISO.
Well, maybe because, I watched this with the FTC. The FTC usually uses prosecution as a way to push settlement to get money in their coffers.
Right.
I say that not hesitantly. I believe that they actually look at.
I think that they advertise they do that. The FTC.
Maybe
their whole.
But wouldn't an
thing is
AG's
get money.
office? Isn't this now the Illinois AG's ability to get funding outside of the public budget? Maybe. I mean, if
Yeah.
they're the ones that are watchdogging it and then assessing the penalties and fines, and it's similar to you don't pay. We had another client that had a lender's license in the state of California. They failed to file a California state tax return in 2000. And in 2025, they had an issue with the Department of Financial Protection and Innovation, which is the watchdog agency in California for anything financially related where there's a license required. When I went to discuss settlement, and it was literally like a late annual filing, that's all it was. I couldn't actually negotiate a settlement with the DFPI because a 2000 tax return hadn't been filed, and almost commensurately, so I don't know if they're talking to one another, the franchise tax board suspended the corporation, and it took 8 months to get a updated filing, and we're talking about an $800 issue, right? So, what happens? Do they just start suspending corporations or limited liability companies that are somehow not in compliance?
I don't know. I mean, it is a potential nightmare, and the solution. It's funny because it's going to be the ISOs responsible for it, but they're not going to be the ones responsible for writing the technology because it has to come from Visa and MasterCard unless you're just going to eat it.
Yeah.
And I bet the initial one will be, yeah, you're just eating it.
Yeah. Well, the process.
You'll program the software to do that, but it's still getting charged. It's just not to the cardholder.
Yeah. Well, the question is will there be any ability for the party programming the equipment to do something that would affect that technology?
I would say yes. Right.
I would think so too.
Yeah.
Yeah, I would think so too. But identifying what that is presently, I don't know because I don't know how they're going to implement it, and I don't think they've said it. Yeah.
No, and I don't think they've said it. If we could get the processor to come on, we've asked Fiserv to come on. I think she said yes, but she needed to
get authority.
She needed like a script beforehand and to make sure that I don't go off script, which I would be biting my tongue.
Yeah, she needs creative authority on it. Yeah. But it's the interesting part is that when looking at how it's going to trickle down and really fall on the ISO, I don't know what causes it, but there's these spikes in processor behavior where things happen. And I'll give you for instance. I got a case right now that I'm working on. Our client did business with a large processor. And I won't crap on them right now. It'll be public because there's no arbitration provision if the processor decides to move forward. But the processor and our client entered into a series of residual purchase agreements from 2018 to 2020, or 2019 to 2020. The first one, they went back and forth on a purchase price and identity of the merchants. Our client got the merchant list, corrected it, and said, no, these aren't the merchants, sent it back. They updated the purchase price, sent back a merchant list. He had presumed that they were in agreement when he redlined it. And lo and behold, evidently they're not in agreement. And that wasn't discovered. In addition, after the revenue that was purchased related to the merchants that were identified, the processor never segregated out those merchants from his portfolio for like an 8-month period.
Oops.
So he's getting paid on those merchants for 8 months, but he's not really paying attention to a lot of this stuff, and he's putting in new merchants all the time. Does a couple more residual purchase agreements. Flash forward to 2024. 2024. He doesn't think he's being paid properly on the remaining merchants that were left over after these agreements. And so he goes to him and he says, hey, I think, I've kind of looked. I think you guys owe me about $73,000. They come back and go, well, actually, we went back and looked at all this stuff and you owe us 3.6
million.
Yeah.
Yeah.
And I see that as and I just was talking to another industry attorney yesterday that told me that Fiserv related to a PayFac, exact same thing just happened. He went to them and said, his client went and said, hey, I believe that you've miscalculated this. And their first response was, oh, you didn't notify us within the first 60-day period. And he's like, well, look, I couldn't have had any of the information or detail to be able to identify this.
Yeah, and I'll always put in the agreements, because you see that all the time. If you don't notify us in these dates, then you've waived it. And I'll put in the language like, look, unless I couldn't discover it.
That's right.
But that language isn't necessary because that's how the law works. Is if I have no way of knowing, or you're actively concealing it, which we see all the times with the processor. I mean, the whole system is made to actively conceal.
Well, the funny part was the response that he got back. It was like $1 million issue to him. The response that he got back was, well, we haven't been passing through all these interchange fees, so you owe us $2 million.
Yeah,
it's
so
like,
just be quiet.
Yeah,
and go away.
Basically,
and they're going, but we won't collect that from you if you shut up and go back to bed.
That's right. Oh yeah, let's memorialize that we don't owe you anything and you don't owe us anything.
Yeah, right? Exactly.
Thank you for listening to this episode of the Payments Experts Podcast, a podcast of Global Legal Law Firm. Visit us online today at globallegallawfirm.com. Matters discussed are all opinions and do not constitute legal advice. All events or likeness to real people and events is a coincidence.